It is my absolute pleasure to welcome each and every one of you today to this expert hour on behalf of the fourth floor and also Poler Legal. The topic today is negotiating co-founder agreements and handling co-founder disputes. As I mentioned, we're going to be doing our best to allocate time at the end of today's discussion for questions from the audience, so don't be shy, put them in the chat, use the queue. Please make sure to keep yourself muted, keep your camera on if you want. Also drop your LinkedIn handles in the chat if you want to. We encourage that. It's just great networking technique. And then before we dive into the actual presentation from Emily today, I just wanted to say a very brief word about the fourth floor. For those of you that don't know or who are not already members, the fourth floor is a market network. It's the best way we can describe ourselves. A market network that exists to diversify boardrooms and cap tables, and we are on a mission to close the gender power, wealth, and funding gap by advancing for-profit board careers for women, supporting women-led startups and funds, and providing women opportunities to invest in other women. So there's lots of different ways that that's happening. There's exchanges inside our platform and inside our community. There are companies that are part of the fourth floor and individuals that are part of the fourth floor, and people are exchanging board opportunities and investment opportunities. And the mission of this particular market network ecosystem is to shift the balance of power for women. However, there's plenty of opportunities for men to participate as well. If you are a founder of a company that is looking to build out a board, or if you want to sponsor women. So there's lots of ways that you that you can get involved as a man as well. So just wanted to explain what we're about, who we are, and if you're not a member, but you are interested in advancing either your board career or investment career by investing in a woman-led startup or fund, consider joining us. You can sign up for a platform tour. We'll put that link in the chat. You can also sign up for our wait list through our website. We're in the middle of transitioning to a new platform, so we haven't opened it up yet to new members, but we will soon. But you can sign up on the wait list. And if you want to join us, but you don't want to pay a membership fee, then please indicate that when you sign up on the wait list, and we can help you advocate with your employer to get your employer to nominate you, to underwrite the cost of you joining us as a candidate or as a potential investor. We would love that, because then we can encourage your company to use our board seat exchange and build out their board with women in our ecosystem. If you are a founder, so you are a woman who is a founder or is maybe going to become a founder, and you would like to join us in that capacity, please indicate that as well when you sign up on the wait list. And we can work with you to make it work, to find a way to enable you to join us. And if you're a founder who is not a woman, you can also sign up to join us, and your company can benefit from the board seat exchange as well. So just want to make sure everyone knows that, and the wait lists are in the chat. Enough about the fourth floor. Let's get to the point of today. It is my absolute pleasure to introduce our amazing presenter, Emily Poler. She is the founder of Poler Legal. She is a self-described smart, no-nonsense lawyer focused on crafting solutions that reduce risk and allow clients to focus their attention where it belongs. I will let Emily introduce herself at more length, and I'm sure we'll do a better job than I will. I'm just really excited for our community to get this content today, because as I mentioned when I posted about this event on LinkedIn, I think it's 65% or over 65% of startups, they die of natural causes. It is conflict amongst co-founders that can wreak incredible havoc. So being able to get out in front of all of these potential issues is so incredibly important. So just really, really grateful that we are getting to benefit from the wisdom that you're going to share with us today, Emily.
Thanks, Breen. I appreciate it. I appreciate the opportunity to be here. And sort of a couple of housekeeping matters before I get started. Because I am a lawyer, I have to say it, just as an initial matter, nothing in this presentation constitutes legal advice, and I'm not forming an attorney-client relationship with anybody by giving this presentation. Sorry for the formality, but in my nature had to do it. I just also sort of want to note that today is the first day of back to school for my kiddo, and I unfortunately means I didn't probably get to rehearse this as much as I would have liked, so bear with me. It also means, I don't know if it comes across on camera, but I played hairdresser last night because my kid wanted purple hair for the first day of school. And so my hands, I looked like I strangled Grimace a little bit, but I'll try and keep them out of the frame. So this presentation is adapted from a talk that I'm going to give to attorneys in about a week or two. And I've adjusted it more for a lay audience, and I'm hoping really that it's neither sort of too advanced nor too basic. And, you know, as I think Breen said, hopefully there will be time for questions at the end. My email address is up on this slide. And if there's something that you don't feel comfortable sharing in the group setting or whatever, and you want to reach out to me separately afterwards, feel free to do that by email or on LinkedIn, where you can find me. Just so by way of background, I'm a commercial litigator, and that means that I represent organizations and individuals in fairly complex commercial disputes, and my clients sort of span a range of industries, but tend to sort of fall into one or more of a couple buckets: technology, art, intellectual property licensing, and finance. As a commercial litigator, I'm largely involved in business disputes, and I started really working on this presentation because really for a couple reasons. One, I think that a lot of attorneys and other professionals sort of ignore some of the emotional and personal aspects of this relationship, and sort of, as a result, miss some details that I think are important, and that, you know, through my 20 years of practice have seen come up over and over again. The second reason is that I get a lot of people sort of on the back end when there's a dispute, and people have, you know, sort of started a business with the best of intentions and probably had a lawyer, and the lawyer or their co-founder hands them an agreement that says, hey, this is what's going to govern us operating this this organization, this company. Sign it, they tuck it in a drawer somewhere, don't really think about it for the next 4 years, don't update it, don't necessarily understand what it means or sort of how it fits into the overall running of a business and why it's important. And the third sort of related reason is that, you know, as I mentioned, I tend to work with people on the back end when a dispute has come up. But there's a lot, I think, of the skills and considerations that I take into account in helping clients through those types of situations, and in negotiating people out of those types of situations when there is a problem, that I think are equally as applicable and equally as helpful sort of from the get-go, and in fact probably be even more effective from the if employed from the start, where there's less water under the bridge and perhaps less of a negative history that's built up over time. So, you know, just to sort of sum up, my goal here is really to demystify the process and hopefully help people understand it, and fit it into the larger picture of running a business, and also hopefully to give people some food for thought in how to go about, and some important considerations in for negotiating a co-founder agreement or a co-owner agreement. Okay, so next up, I have here sort of some of the topics that we're going to be covering today. So first off, I'm going to spend a little bit of time talking about the types of entities that are covered by this presentation. I'm also going to talk a little bit about why I think this matters. Breen, I think you mentioned that approximately 65% of all startups have fail or sort of don't survive. And I think that disputes among co-founders and sort of an understanding of the process can be an important reason that companies do not survive. I'm going to give a very basic overview of the process of forming an entity and negotiating a co-founder agreement. I'm also going to talk about some important aspects of effective agreements. And there's sort of two parallel tracks here. One is sort of what I like to see in an agreement as far as sort of the nuts and bolts, and the other is more sort of procedural and thinking about how do you get to that point. And then last, I'm going to close the presentation by talking a little bit about what happens when there's a dispute, and again, hopefully demystifying that process a little bit. Okay, so types of entities covered by this presentation. You'll see I have 4 types really listed on this slide. The first 3 are really what I'd call formal organizations, and they're partnerships, limited liability companies, and corporations. And these 3 types of entities, and I know some of you are lawyers on here, so bear with me because this is probably pretty basic and you remember this from law school. These 3 entities, in some shape, manner, or form, regardless of what state you're in, you have to go to the state where you're located or going to be doing business and say, hey, you know, state of New York, state of Connecticut, state of Wyoming, whatever, I'd like to form this type of entity. And the real point here is that the entity keeps your and your co-founder's assets separate from those of the companies. And that's important because for the very basic reason that if the company gets sued, your personal assets are not on the hook. It's sort of outside of the scope of this presentation because there are separate considerations. Not-for-profit entities are sort of a 4th type of entity. As far as what I've got listed here, the 4th, what I've termed informal partnerships, sometimes situations arise where without meaning to, or sometimes with meaning to, people accidentally create companies or what are viewed as companies by courts and the law. It's best to avoid this situation. Just not great. It sort of gets you into sort of a little bit of a legal, or it can end you in a little bit of a legal limbo where it's like, do I have a company? Do I not have a company? What rules apply? I'm just noting it here because it is something that's worth sort of thinking about and being aware of as something to avoid. But I'm both going to spend most of the time focusing on the first 3 types of entities. And the biggest difference for today's presentation really is that there's some difference of language. So for example, partnerships have partners, whereas limited liability companies have members and corporations have shareholders. And for partnerships, you would have a partnership agreement. For a limited liability company, you would have an operating agreement. And for a corporation, you would have bylaws or sometimes a shareholders agreement. And there are, I will just mention, and it's really outside of the scope of today's presentation, there are also tax differences in how each of these entities and their owners or co-founders are taxed for each of these entities. That's really a question for another day. Maybe we can do a panel with an accountant as well some other time. Okay, moving on. So why does this matter? Well, so in 2017, small businesses accounted for almost half of all people employed in the United States. That's a pretty significant number. And I think, as Breen mentioned, a lot of companies sort of unfortunately meet an early end, and some of that, it's hard to sort of come up with exact numbers, is due to some form of dispute among co-founders or co-owners. I've seen a variety of numbers thrown around. I think the one that comes up most commonly is that 35% of all businesses have some form of dispute between co-founders. I've never actually been able to track down where that number comes from. It's like one of those things you see all over the web, but it's like, as far as like an actual source, I have no idea. So we'll just leave it out there as some large number have disputes. And I think what we have seen, what I have seen in the last couple of years, and what I think we will continue to see, is with the pandemic and the Great Resignation, more and more people, either as a side hustle or as their primary gig, have been stepping out and starting businesses on their own, either alone or with other people. And I think that that will, in coming years, influence the overall economy and play a role and make it important for people to understand the role that co-founder or co-owner agreements play when starting a company. Okay, so turning to sort of the meat of the presentation. On the next slide, I'm gonna go over some reasons people don't have a co-owner or co-founder agreement, but I'm curious if anybody has any thoughts, and I'm happy if people can throw into the chat some ideas as to why people might not sit down and write a co-founder or co-agreement. If you've got something, just throw it on in there. All right, nobody has any idea. Oh, okay. Okay, we've got, they don't want to upset their co-founders. Yep, absolutely agree. Don't feel it's necessary. Trusting that everybody has both everyone's best interests in mind. Scared to figure out the equity. I got a ditto for that. They don't want the other co-founder to feel they don't trust them. Yep. Don't want to pay lawyers. Yeah. Equity has totally paralyzed me. They don't know what they don't know. I think that's a great one. Yeah. I think so. I'm actually really happy to see this. I'm going to put up my list, and avoiding tough conversations. Yeah. So this is my list that I've sort of come to, and I think it echoes a lot of and Breen just put up, don't want to get their own lawyers because then things become oppositional. And this is my list, and I think it sort of echoes a lot of things that people have said, but now I'm going to edit this after this presentation. I'm going to edit this slide to include some of the great things that people have put up. So no time. I mean, I think, you know, we all live with the same 24-hour day, and you know, you're trying to start a business, and I see this a lot, and there's only so much you can do in a day, especially, you know, if you've got responsibilities outside of your business, or you have a full-time job on top of a side hustle, or you've got a family or other people depending on you. There's just only so much time in the day. And this is just one of those things, I think, in conjunction with sort of the other things that are on this list, and not wanting to maybe have difficult conversations, has just a habit of sliding down that to-do list. You know, I think it's human nature. I think it happens. You know, and I think the not knowing what you don't know and sort of being afraid to ask is probably also something that allows this issue to sort of drift further and further down the to-do list. No money, or not wanting to spend money on lawyers. You know, I think especially when you combine this with, like, you're going into a business, this is sort of a hopeful time, and you really think like you're going to get along, and like you've got this great idea and this great chemistry from the outset, like, of the things I have to spend money on. Why would I spend money on a lawyer, having a lawyer write this? Or why would I spend time sort of thinking about what could go wrong, because we're in this really like great space and we're doing this exciting thing, and why, you know, why sort of take time away from all of that excitement? I think that's a reason that in some shape, manner, or form comes up a lot. Not wanting to have conflict or really hard conversations. Look, this is a process that can sort of reveal where people agree and disagree, and sometimes that's not always pleasant, and we don't always want to face the issues that are going to come up and be revealed by those types of discussions. And sort of relatedly, the fear of what those conversations are going to sort of show about us and about the person we're choosing to go into business with. Okay, moving on. What are some reasons to have a co-founder or co-owner agreement? Just again, throw them in the chat if you don't mind. All right, I'll put up my slide to give people some ideas. So you don't have misunderstandings. Clarity clarifies decision-making. Hope for the best, plan for the worst. You need to plan for the exit, to know where you stand. Yep, all of this. You know, effective exit. So align expectations, exactly. there's an expression, I don't know where it comes from, but I've certainly heard it. Good neighbors make good, or good walls make good neighbors. And I think that, sort of knowing where good fences, I'm sorry, there we go, I got corrected, but good fences make good neighbors. That's the correct expression. I have been known to say I'll burn that bridge when I come to it, so it's not unusual for me to mangle an expression like that. So I think that, I frequently compare this process to like when you take the test, the written exam to get a driver's license. You have to learn what a stop sign looks like, right? If everybody doesn't know what a stop sign looks like when you come to an intersection, and what you do when there's a stop sign at an intersection, and who goes first when it's a four-way stop sign, there's going to be confusion and there's going to be problems. So making sure that everybody has the same basic understanding of how things work, I think, is super important. And going back to this idea of good fences make good neighbors, having these conversations is important because what's important to you, what's important to your co-founder, and how each of you sees the world and how you expect the world to operate. I think another reason that's really important to have a written agreement is because it can be easier to have these discussions early on. And there's really two reasons that I see for that. One is, hopefully you start a business and your business is super successful and you make tons of money. Well, that's great, but unfortunately sometimes having lots of money makes people fight over money. I think we've all seen this. It's not surprising, wouldn't be surprising to anybody. And so doing it while there's less money and less at stake may be in fact easier. And then also doing it where there's a lot of history and a lot of perhaps past slights or interactions that may have gone positive or may have gone badly may make the conversations easier, doing it with a fresh slate. I think it also is really good to know up front if this isn't going to work out. Better to have the hard conversations at the start and say, you know what, you're great, we had a great idea, this is fabulous, I think this could be great, but the two of us or the three of us or the four of us, this isn't going to work. Let's figure out something else to do so we can all move on in a positive manner. And on a related note, if you have these hard conversations, what I frequently see is that business isn't always going to be rosy. It's not always going to be perfect. It's rarely going to be a situation where everybody gets along all the time. Hopefully the business has a nice long run and goes on and is super successful. But, I think that being able to have conversations and listen and understand where other people are coming from and acknowledge their feelings, but also move on and not have everything go 100% your way or 100% your co-founder's way is sort of an important prelude for successfully operating in a business, but also in life more generally. There's going to be moments where you disagree and you need to figure out how to have those respectful disagreements and work through them and come to something that everybody, if not 100% happy with, can at least agree on and move forward with. And then I'll just run through these last, I feel like I'm belaboring this, but we'll just run through these last 2 points quickly. Can save time and money in the long run. Litigation, trust me, I know it's expensive. It's what I do with most of my life. It's expensive and it's time consuming. And if you can avoid being involved in litigation, I highly advise staying away. And then also just from a big picture view, it may be having this type of written agreement and having effective procedures in place to ensure that you're in compliance with the written agreement may be important to bringing on outside investment. Okay, so what are some important elements of a written agreement? Well, one, you want to make sure it accurately reflects the co-owners or co-founders, one, understanding, and two, their actual practice. Not infrequently, and I think I mentioned this previously, people will sort of form a company, their lawyer or whoever will hand them a form that they pulled off of LegalZoom, and they'll sign it and tuck it in a drawer and not really think about it. Not ideal, because from a legal point of view, whatever your practices are, the written document by and large is what's going to control. So if you're going off and operating in one manner, but your written document says something else, and you come to a point where you're in a disagreement with your co-founder, it very likely will not matter what you've been doing for the last number of years. Second thing that I like to see, and I think is important, is rules of the road. And this is sort of going back to my stop sign analogy, there's sort of a process or a procedure to go through to reach a decision and for specific types of situations, but also the agreement recognizes that you might not be able to address every possible situation in advance. I mean, I think the last couple of years have shown us life is going to throw people curveballs, and it's not always possible to anticipate. In fact, it's frequently not possible to anticipate everything you're going to see. And then addresses what's going to happen if there's a deadlock or a dispute. And I think a couple of people put this in the chat, to make sure that there's a way that you can exit, or you or your co-founder can exit from the relationship if things aren't working out without torching the business. And one thing that's sort of along those lines is to include a method for dispute resolution. And here, and I have this in quotes, non-legal issues, not to suggest that these are things that are illegal, but to suggest that I think, and I referenced this sort of when we were first starting out, I think that there are some things that frequently get overlooked in sort of trying to address co-owner or co-founder agreements, which are sort of quote unquote non-legal issues. So as I just referenced, making sure there's a process that people feel good about for people to come to decisions, that there's a way to consider different possibilities and the outcomes of those possibilities, and also to think about how people are going to approach that, how you and your co-founder are going to approach situations differently. And I think the sort of underlying thought here is that, yes, this is a legal relationship, much like marriage is a legal relationship in some ways. But it's also an intensely personal relationship, and can really resemble a marriage. And I don't think I will be the first person to compare co-founder relationships to a marriage. And the dissolution sometimes can come to resemble a messy divorce. And there's a question from Christy in the chat: what are some examples of sensitivities in this context? So just to address that question, so for example, if you or your business partner has been in a relationship like this and it has gone badly in the past, that can be a really important consideration. It may be super important for you or your partner to have a mechanism to exit more readily, or make it harder to exit because the person is just jumpy about this type of relationship and sort of starting over, just like somebody who's been divorced might be jumpy about starting over and getting remarried. And so all of this is to say, and just to sort of sum up here, that co-owners and co-founders really need to pay attention, and their professional advisors need to pay attention, and not sort of just check the box and be like, yeah, we figured out how people are going to exit the business, and we figured out how people are going to join the business, and we figured out how people are going to put in money to the business, or how we're going to sell the business, but also think about how you make those decisions and the process where you make those decisions. Okay, so what does this mean in practice? And this is sort of summarizes, and I'm just going to move my monitor around a little bit, so bear with me. So this is sort of some things that I frequently advise clients to do more in the dispute context, but I think it's equally important when you're having these discussions, to listen to the other people in the discussion, avoid an internal monologue or sort of rushing to a decision. I think it's really common for people to be like, yeah, I've heard what you're saying. I get what you're saying. Let's move on. Let's just do this. But I really encourage my clients to sort of stop and take a breath and not do that, and avoid sort of jumping to the conclusion that you've jumped to 30 times before because you've had this discussion. I think in practice, and when negotiating a co-founder agreement, I think it's super helpful to work with either on your own, or if you're working with an accountant or a lawyer or a coach, to develop a plan and the priorities that you prioritize the things that you want to see in this agreement, but also recognize that that you need to be flexible, and that nobody's going to be 100% happy with the finished product. At least nobody should be 100% happy with the final product. There's, as a lawyer and as a litigator, there's an expression that a good settlement agreement is something that nobody's happy with. Nobody's 100% happy with, because and the idea there is that it represents compromise. And then I think also, to, going back to this idea of people having particular sensitivities, I think it's important to consider the things that are said and things that are left unsaid, and the sort of point of view that people are coming into these discussions with. And this is sort of, in my view, the advantages of this approach is I think it leads to more creative problem solving, the willingness to listen to people. And I think there was a presentation a couple months back, or maybe 6 months back, by another lawyer, fourth floor person, about mindfulness and negotiation. And I think probably we share sort of some ideas here and sort of some similar approaches. I would encourage, I don't remember her name, Erin something or another, but anyway, I would encourage people sort of wanting to delve more into this topic to also maybe go and look at that presentation as well. And I think this approach and sort of the listening required by this approach can really result in more positive view of the outcome. With that said, there's not really any research saying that this is going to lead to better outcomes, or, there's no sort of hard evidence. So if that's what you're looking for, sorry. And quite frankly, it's not for everybody. I am a native New Yorker. I am very much like to the point, like, let's get this done. I can certainly see situations where people are like, yeah, all of this talking about feelings is very nice, but like, let's move on and just get this done. So going into this kind of negotiation, what I really encourage people to think about are, what are your goals and priorities? Why are they your goals and priorities? And I'm not going to read through it because there's a whole list of things here, but I do think, thank you, Kat, you put it up. Kat put up a link to that talk, which I thought was super helpful. But I do think that this sort of gives a list of some things I like to ask clients to think about and consider going into a negotiation, whether there's been a dispute yet or you're just starting out from scratch. And I think, although they're the last 2 points, I think I'm just going to underline them because I do think they're important and really things that I encourage people to think about, which is what will happen if you compromise and how will you feel if you compromise. And not only how will you feel if you compromise in that moment where you're doing the compromising, but how will you feel and what will life look like 6 months down the line, 3 months down the line, a year down the line, and sort of try and envision sort of the different alternatives there. And this is a list of some approaches that I use, both in helping people negotiate agreements as well as where there's been a dispute. So a questionnaire, just sort of a piece of paper, you can I have one, I'm sure other lawyers have one, of questions that are important for people to think about when entering into a co-founder or co-owner agreement, and sort of the things that need to be reflected in that agreement. A joint brainstorming session can be helpful, or if things are perhaps a little more antagonistic, a facilitated discussion. Mediation, I find, can be super helpful. It's a sort of an outside third party who can help people see where they agree and disagree. And I'm rushing a little now because I do want to leave some time for questions at the end. So important pieces of a written agreement, and sort of this is a summary of what should be in a written operating agreement or partnership agreement or bylaws. And going back to the questionnaire I referenced on the last slide, if you wanted to do this for yourself, this is sort of some important things that some considerations you could put in a questionnaire and work with your co-founder or co-owner to go through and figure out, like, what are the answers and where you agree and where you disagree. So who's responsible for what? Is there a mechanism for roles to change over time? So, for example, somebody needs to take maternity leave or step away from the business for 6 months because of family concerns. How does that happen? Do all owners or all co-founders have to work in the business? Is everybody working full time? Are there performance indicators? What happens if those KPIs are not met? How are decisions made? How do you manage the business? So there's sort of the big picture of making the decisions, but then who actually implements the decisions? How are records kept? Who has access to them? If the business is running out of cash, how does it get more cash? How does money get taken out of the business? You've had a great year and you want to pay yourselves. How does that happen? Can somebody be removed from the company because, for example, everybody's supposed to be working in the business and they're not? And what does that look like? What happens when there's a dispute? Can you dissolve the business? And can co-owners found businesses that compete with the business? And that's, it's by no means all inclusive, but I think it gives you some indication of the important considerations for a written agreement. And the next couple slides, I'm just going to run through some of the things that I suggest as far as potential alternative management, potential alternatives that could come up, that could be used to answer the questions that I had on the last slide. So here are some alternative management structures. The business is managed by all of the owners. The business is managed by something less than all of the owners. So you have 3 owners, but one is the manager, and that person is responsible for hiring and firing staff and maintaining the bank account and leasing space for the offices, that kind of things. Managed by a non-owner. So let's say there's 3 owners and everybody hires a chief operating officer, and that person is responsible for doing the day-to-day management of the business, or some combination of these. Here are some examples of a decision-making process. So majority rules, 51% of the ownership of the company and you get your way. Super majority, it could be 55%. There's no sort of set number for super majority. It could be 55%, it could be 60%, it could be 75%. It's going to depend on how the business is, how the sort of ownership of the business is allocated, that is going to sort of have an impact there. So if there's only 2 owners, if you need supermajority, it's going to be unanimous consent if both of the co-owners own 50%. Unanimous agreement, and then consensus. And just to sort of talk about consensus for a moment, consensus really, I think a lot of times people confuse consensus with a unanimous agreement. And consensus really is much more, from my point of view, having a place to have a discussion about different people's concerns and points of views and suggestions, and having people come to a place where they accept that agreement, even if they may not completely agree with it 100%. Some examples of how people enter and leave the business, a buy-sell provision. So for example, this would be where somebody, let's say one person owns 80% of the business and one person owns 20% of the business, and the 20% owner wants to leave the business and says, hey, I want you to buy my 20%. So that I can leave. And the 80% owner says, I don't want to buy your 20%, but I'll let you buy my 80% on the same terms. And the parties go back and forth there. There can also be a right of first refusal. So again, with the 20% owner, they go out and buy, they go out and find somebody who wants to buy their 20% of the company. And before that new potential owner can come in, they have to go to the 80% owner and say, hey, I've got this offer to buy my 20%. Before I sell it to this third party, do you want to buy my 20%? And then the third option that I have listed here is unanimous agreement for a new co-founder. And sometimes this can be important and helpful because, you know, especially in a small company, you don't want to necessarily be in business with somebody who you don't know and haven't approved of them joining the company. All of these different methods and of decision making and different possibilities have, you know, different positives and negatives, and you just have to, you know, walk through what's either with your co-founder or with professional advisors, what's right for your particular situation and sort of what you can live with. And then here are some methods of dispute resolution. Regular meetings, just to make sure that everything's out in the open and things are getting discussed and things are not getting swept under the rug. Along those lines, use of a coach or a facilitator to sort of help bring any issues out. And this, you know, I think you can think of this like a marriage counselor. You can select a third party in advance of any dispute. So in writing this agreement, in writing a co-founder or co-owner agreement, you say, hey, if we can't reach an agreement, if there's a topic that comes up where we can't decide, this person we've chosen we'll each make a short presentation to her, and then she'll decide which way we should go. Alternating decision making, you know, on the big certain predefined issues, each co-founder gets to take a turn. It could be for 6 months and then 6 months, or it's one then the other. And again, you know, all of these possibilities have their positives and negatives. And mediation, again, this is sort of another flavor of the coach or facilitator. Generally, a mediator is a lawyer, but not always. And then, you know, quite frankly, I've seen this and I've seen it work, is flipping a coin or drawing straws when there is a dispute. It's not for everybody, but certainly people do it. And then here are just sort of some other things that I've just don't necessarily fit anywhere, but I think may be important to this process, and things that come up a lot. Conflicts between junior and senior members is something I see a lot. You know, you have somebody who founded the business and built it for 20 years, and then they bring in a new partner, and the new partner's like, hey, let's do it this different way. And there's sort of a different skill set that new person brings, maybe because they're younger or they have, just different abilities. And so sometimes there can be resentments because the junior person feels like, hey, my sort of what I'm bringing to the company, yeah, it's different, but it's not being appreciated. And the senior member feels like, hey, I built this company and I spent 20 years. Who are you coming in to tell me how to run my business? I'm the one who's made this a success. Another consideration to sort of that may need to be thought about is if you're bringing on somebody new, whether there's sort of a structure for that person's interest in the business to vest over time and what that looks like. Again, and I think this is a theme throughout, that being heard can be a really important part of the process, even if everybody doesn't agree, that just having that space to have people talk and listen to each other and feel heard can be really important. And that sometimes conflict it can be good, both because it brings ideas out into the open, and because sometimes it helps people know when it's time to move on. And then one last thing I just want to mention here, which is that as a member of a limited liability company, or as a shareholder in a small company, or a partner in a partnership, you frequently have fiduciary duties, or almost always have what's called fiduciary duties. And in plain English, that means that you have an obligation as an owner of the company to act in the company's best interest. And that the company is separate and apart from its owners, and that those interests have to be protected, and you can't go around doing things that are against the company's interests. So for example, taking the company's clients would be a big breach of fiduciary duty. Those can be waived in some states and in some situations, but it is just something to be mindful of in the process of creating and operating a company, and creating a operating agreement, or a partnership agreement, or shareholder agreement. Okay, and then I'm going to spend a few minutes on disputes, and then we can wrap this up by taking some questions. So, and I see some questions are there, so I'm going to just run through this super quick. So when there's a dispute, I think one of the first things I always ask people is there a written agreement? And if so, does it have anything to say about the particular dispute? If there's no agreement, or the agreement is silent, what does the law of the relevant state say? And how does that impact the situation? And are there any dispute resolution procedures that we need to be looking at? And those are sort of, from a lawyer's point of view, the first steps. As a business owner's, from a business owner's point of view, I think some important considerations are, how is the company going to continue to operate? What are you going to tell the employees, if anything? How are you going to communicate with your co-owner or co-founder if a dispute has gotten to the point where you're not really so happy talking to one another? And how do you sort of work through that situation? And are there reasons not to address the dispute? So for example, if you're about to sell the business, maybe it's better to just sort of suffer in silence for 6 months and then sell the business and move on. I'm going to skip this slide. Again, to re-emphasize, even when there's a dispute, members of a company owe a duty of loyalty, a duty of care, and a duty of good faith, fiduciary duties to the company. And people owe these duties not only to the co-founders, but also to the company itself. And again, they can sometimes be waived in the written agreement, but frequently are not. So it's just important to be very mindful of them. Things to sort of think about, and this is a similar list to what I talked about being important in negotiating an agreement. And these are sort of things to think about when trying to get out of a dispute. What are your goals and priorities? Where is their agreement? Where is their disagreement? Can you live with? And what will it look like if you compromise? And what will life look like a year down the road if you compromise? Again, this is some more stuff to think about. And this slide summarizes, and I'm sorry, I'm rushing, sort of the steps of litigation. If there is a dispute, my point with this slide is that litigation can often be a expensive and time-consuming process. This process can take from the initial pleadings, if there is a dispute and it gets filed in court or in arbitration, from initial pleadings to appeal can take 3 years or more, and cost a lot of money. So just to have your eyes open as far as sort of what can happen if and when there's a dispute between co-founders. And then one of my favorite ways of trying to resolve disputes is mediation. It's voluntary submission of a dispute to a neutral third party. As I mentioned frequently, the third party will be a lawyer, but the parties generally are very skilled. The lawyers, the mediators are generally very skilled at helping people sort of accurately evaluate the costs and benefits of moving forward. And if it's okay with everybody now, I'm just going to sort of circle back and take some of the questions rather than continue on and sort of rushing through. Is that good?
I think that sounds good, considering there are a number of questions in the chat. And if you just want to read them, Emily, and answer, or if you want me to feed them to you, just let me know.
Okay, so Green asked, should co-founders always go out and retain separate counsel, or can they waive conflict and be jointly represented by the same lawyer? Where there is no dispute, or where a dispute has not arisen, I think generally in most states, the ethics rules will allow a lawyer to represent the company and all of its members or founders, where there's a dispute that if in that process it becomes evident to the lawyers or the parties that there may be sort of some significant areas of dispute, then the parties should have separate counsel to negotiate.
Right, and really the context of my question, I specifically like when co-founders are first negotiating their partnership agreement or the LLC agreement, or whatever the terms are that will govern, at that point, do they want to retain separate counsel, or do they rely on the one lawyer?
I think that generally speaking, assuming things are fairly harmonious, that one lawyer can do it representing the company, and it'll save everybody some money and some time to not have separate counsel. Obviously there's advantages of saving money. There's a disadvantage of not having somebody who's purely out for your interest and your interest only. Right. Everybody has to sort of judge the risks and benefits there for themselves.
And actually, to skip it, since many of these are my questions, I feel like I know we're down on time. We don't have that much time left. I wanted to flag my last question because it's kind of related to this first question. So you mentioned vesting, but you just mentioned it quickly in passing. And in my experience, I just think this warrants a little more focus, because one of the, I think oftentimes when people are new to being a founder, negotiating these agreements, they might just agree to an equity split, kind of like a handshake, but then you can run into a situation where one of the co-founders that gets this equity stake then stops being involved, doesn't engage, isn't contributing any value. And if you haven't thought about vesting and you haven't incorporated that into your negotiations or into the agreement, then you can be left in a situation where you've given a bunch of equity to a person that now owes you no obligation, which is a very bad situation to find yourself in.
Yeah, I mean, in that situation, I've seen it arise both both where somebody gets an equity stake from the get-go, or like somebody comes into a business and the more senior member of the business is like, cool, I got a new member, I got a new person involved in this business, I don't need to work anymore, bye, I'm out. And I think that this sort of goes to the point I raised, and it was on my list of one of the things I sort of really encourage people to think about is, does everybody have to work in the business? Are there particular KPIs for each owner that they have to hit? What happens if they don't hit those KPIs? And sort of, and this is, I think, also going back to my point about thinking about how life looks like in a variety of different scenarios in 6 months or 3 months or a year. I think you need to play through those possibilities as part of the process of drafting a co-founder or co-owner co-founder or co-owner agreement, so that you don't just sort of sign something don't really think about it that much and shove it in a drawer. I think it's important to have it be a living, breathing document that really reflects your aspirations for how, and your expectations for how the business is actually going to operate. Does that answer you?
Yeah, no, I think that was helpful, and I think even just if anyone listening who might be in this situation where they're trying to, negotiate relationships with co-founders, just being aware of the fact that there are lots of different tools and levers that you can use to your advantage to structure the relationship in a way that's going to work for you and work for them, and like get rid of the ambiguity. I just I feel like for a lot of people, they just don't know that. You know, it's not obvious that that's something you should be thinking about, or that there are ways to do it. So if you talk to someone like Emily, she'll know all the different techniques and tools and things that you can use as a co-founder in that.
And look, there are form agreements. I mean, like LegalZoom has a business model, it works. Obviously they wouldn't still be in business if it didn't work, but that's not going to be specific, and those situations are not going to be sort of thought through. Right. Breen, I'm going to skip your next question and sort of get to some other people. I hope that's okay.
Oh yeah, no, absolutely. I'm not sure if I saw another. It looks like someone wants you to repost the things to talk about slide.
Sure, I can do that. Also, somebody posted, Gail posted, it's important to consider the law of the jurisdiction on both of the above. Having lived and worked in Europe for 15 plus years, these issues can be very complicated for expat founders. Yes, that's true. Generally speaking, however, in most cases, the law of the state where the entity is created is what's going to apply to any disputes. There are sometimes some ways you can contract around that and say, no, the law of England is going to apply, not the law of the state of Delaware. But generally speaking, if you form a Delaware company and you're in a dispute with your co-owner or co-founder, Delaware law is going to apply, and any disputes are going to be heard in Delaware. And then I'm going to scroll back up. Things to think of. Somebody asked me to put the things to think about slide up again. Let's see if I can do that.
Yeah, and while you get that, there's a new question that just came in. I'll ask it to you while you're getting that ready. It says, for financially strapped founders, when does it make the most sense to bring in legal counsel, if at all, during the negotiation of a written agreement?
I mean, I think that for financially strapped founders, what I would recommend is, in this sort of presentation and sort of elsewhere, I'm sure you could Google it, reading through operating agreements, really making an effort to understand what they say and sort of what's in there and the impact of the different issues might have on your business. And then sort of attempting to have those discussions without an attorney involved, and then being able to go to the attorney and be like, hey, we've had these discussions, this is where we agree, this is what we want to see, can you please put this in writing? And make sure that we have something in paper that reflects our actual discussions. I mean, that would be sort of the most cost-effective way of working with an attorney if money is tight.
Right. Oh, and by the way, I think, can you just go to the previous slide really fast, Emily? And to Ruby, if you are a member of the fourth floor, you'll be able to access this presentation. And if Emily makes her deck available, then we would include that as well. So you'd be able to.
Sure, I'm happy to, after the presentation, I'm happy to email it a PDF and you can distribute it as you see fit. Or people can email me directly and I will send a PDF along.
Okay, awesome. And yeah, I think, I mean, this was a great presentation. I know we're coming over time. It is like Pandora's box. I mean, when you ask one of these questions, so many of the other questions are related, and that's such a good question about when is it worth it to make the investment to talk to a lawyer. I think like if nothing else from this full presentation, if like a really important headline to take away from this is just, if you're not thinking about it strategically out of the gate, then you can end up costing yourself so much money, you know, down the road, because so it kind of is worth it, yes, and like right away, and but to Emily's point, there's ways that you can be strategic and keep the cost down, but at least internally, you know, read Emily's presentation, look at those slides, think about all those things, do the hard work yourself at the outset, because it will save you time and money.
Great, thanks you guys.